Court marriage process of Pakistan. Legal framework. The primary law governing marriages in Pakistan is the Muslim Family Laws Ordinance, 1961. MFLO. Other relevant laws include the Family Courts Act, 1964, and the Nikah-Nama regulations. Preconditions for marriage age requirement. Both parties must be of legal marriageable age. For males, it is 18 years, and for females, it is 16 years, according to the Child Marriage Restraint Act, 1929 nuns. Free consent. Both parties must give their free and voluntary consent to the marriage. Non-existence of prohibited relationships. The parties should not be within the prohibited degrees of relationship unless permitted by religious laws. Documentation required. CNIC, Computerized National Identity Cards, CNIC, or B-form if CNIC is not available. Photographs, recent passport-sized photographs of both parties. Witnesses, 2 adult Muslim male witnesses. Affidavit of single status. Declaration that both parties are single, unmarried, divorced, or widowed. Application for court marriage. Preparation of documents. The couple prepares all necessary documents. Meeting with lawyer. It's advisable to consult a lawyer to ensure all legal requirements are met. Filing of application. An application for court marriage is submitted to the local union council or the marriage registrar. Nikah ceremony, Nikah-Nama. The marriage contract, Nikah-Nama, is prepared, which includes details like the dower, haq mehr. Sections 5 and 6 of the Muslim Family Laws Ordinance, 1961, govern the registration of marriages and the requirement for a marriage certificate. Signing of Nikah-Nama. Both parties sign the Nikah-Nama in the presence of the Nikah registrar and 2 adult Muslim male witnesses. Recitation of Nikah. The Nikah, marriage, is solemnized by a Nikah Kawan, authorized person, who recites the necessary prayers and obtains consent from both parties. Registration of marriage. Submission to Union Council. The signed Nikah-Nama is submitted to the local Union Council for registration, issuance of marriage certificate. The Union Council issues a marriage certificate, also known as a marriage registration certificate. Post-marriage procedures, updating records. The couple updates their marital status in their CNIC and other official records. Notifying authorities. It may be necessary to notify other relevant authorities or institutions about the change in marital status. Special cases. Marriage with a foreigner. If one party is a foreign national, additional documentation such as a valid passport, visa, and no objection certificate, NOC, from the respective embassy may be required. Second marriage. For a man entering into a second marriage, he must obtain permission from the Arbitration Council as per Section 6 of the Muslim Family Laws Ordinance, 1961 non. Failure to do so can lead to penalties and the marriage being declared voidable. Legal provisions and relevant sections, Section 5, MFLO 1961 quote, Registration of Marriages, Section 6, MFLO 1961, Restriction on Polygamy and the Requirement for Permission for Second Marriages. Section 7, MFLO 1961 none, provides for the dissolution of marriage by talaq, divorce. Child Marriage Restraint Act, 1929, defines the legal age for marriage and penalties for child marriage. Court involvement in disputes. If there are disputes regarding the marriage, such as its validity, maintenance, dower, or custody of children, these can be taken to the family court. Family Courts Act, 1964, provides for the establishment of family courts and their jurisdiction over family-related disputes. Example of court marriage process. Preparation. Gather required documents. CNX, photographs, witnesses, affidavits. Consultation. Meet with a lawyer to verify all legal requirements. Filing. Submit an application for court marriage to the local union council. Nikah. Perform the Nikah ceremony with the Nikah Kawan and witnesses. Registration. Submit the Nikah-Nama to the union council for registration. Certificate. Receive the marriage certificate from the Union Council.